SJC-12989, Commonwealth v. Abdirahman A. Yusuf.
Mr. Levin, please.
Thank you very much. Good morning. May it please the court, Patrick Levin on behalf of Abdirahman Yusuf, who appeals this morning from the denial of his motion to suppress. In this case, police responded to a call for a domestic disturbance at Mr. Yusuf's house, and one of the officers, while he was there, made a video recording of the inside of the home without notice and without asking for permission to record. Subsequently, other officers in the gang unit who were conducting an investigation that was unrelated to the domestic disturbance obtained that video recording, made their own copy of it, which they kept on a DVD in their desk, and subsequently used that video to develop probable cause for a search warrant. This sequence of events violated Mr. Yusuf's right to be secure in his house against unreasonable searches.
Your position, Mr. Levin, is that the review of the body cam at some point after entry into the home constituted another, not just search, but seizure that required constitutional justification. Is that right?
Yes, that's right. I'm not sure it's necessary to...
What do you rely on for that, please?
Well, Your Honor, I guess it would go back as far as Katz, I suppose. It's a police action that intruded on his reasonable expectation of privacy in his home. Other cases that I rely on in terms of the subsequent inspection of evidence that the police already had in their custody, potentially constituting a search requiring a warrant, would include cases like Riley versus California, Commonwealth versus Arzola, Maryland versus King, Commonwealth versus Johnson.
Well, before you get to Johnson, which is an interesting choice for a case, what about Justice Gaziano's opinion in Commonwealth versus McCarthy, where looking at the automatic license plate data did not constitute, in that particular circumstance, a search, where you have, of course, much more data than you have from one entry with a body cam.
Yes, that's right, Your Honor. I think McCarthy also supports my position in this case. The reason the inspection of the ALPR data in McCarthy was not a search was that it did not intrude on Mr. McCarthy's reasonable expectation of privacy, because all it revealed was his physical location in public at a few times. In this case, the inspection of the video recording of the inside of Mr. Yusuf's home revealed information about the inside of his home, a location where he's entitled to the most heightened privacy under the Fourth Amendment in Article 14, where all details are intimate, private details.
Mr. Levin, I understand your argument about there being two separate searches, both requiring either permission or a warrant. But let me ask you a hypothetical, and assume for the sake of this question that we find the first recording to be permissible. So this really focuses on the second argument. If the police suspect that someone that he's involved in a string of burglaries, and they surveil the person and he discards a soda bottle, walks away, the police pick up the soda bottle from the trash and they fingerprint it, and they just keep that in their desk with that data to themselves. There's a subsequent burglary, and the police obtain latent fingerprints from that burglary, and they compare it to the soda bottle. Is that okay?
Yes, Your Honor. Commonwealth versus Arzola discusses this in the context of DNA analysis, but it compares it to fingerprint analysis very explicitly in that opinion.
Right.
And
Go on. I'm sorry. I didn't mean to cut you off. Please explain.
So the holding in Arzola is that the DNA analysis of the shirt, it's a shirt in that case that was lawfully seized from the defendant. The DNA analysis is not a search because it doesn't reveal any information in which Mr. Arzola had a reasonable expectation of privacy. Right. And so again, it's the same.
But that's what I have a question about. And I was going to ask you about Arzola. That was my second question about that. Because in Arzola, Chief Justice Gantz writes, where the shirt was lawfully seized, there was no reasonable expectation of privacy to prevent police from analyzing the shirt to determine basically the source of the blood stain, doing a DNA analysis.
Right.
Here, so no reasonable expectation of privacy in the DNA identification characteristics. He had later kind of said, well, if they did a full, I guess, genome, that's a different story, right?
Right. That's right.
But here, the analysis is of someone's curtains, a distinctive pattern in the curtains. How is that information more protected than a DNA profile? That's what I'm trying to tease out from your argument.
Your Honor, I think Kelo disposes of that question by holding that every single detail about the inside of a person's home is an intimate detail in which they have a reasonable expectation of privacy. And so what Kelo obviously is just about the relative warmth of various areas of the person's house. It's a thermal imaging case. But what the court says is that it doesn't matter how little information or how seemingly insignificant the information is. If it's information about the inside of someone's home, that is information in which the person has a reasonable expectation of privacy.
Thank you, Mr. Levin. You answered my question.
Mr. Levin, so I assume that there is a second search for a second. Assuming the first search is consensual, and also I have no trouble with the body cam being turned on, but I know you disagree with that. But assume the first search is they let him in on a consensual basis and it was appropriate for the police to turn on the body cam. Now we get to sort of the next review of that information. I'm just trying to understand how we evaluate that. Because body cam information is type of information we're going to want to preserve, right? It benefits defendants as well as the Commonwealth, right?
Well, Your Honor, that's true if there is something on the video that is relevant in some way to, say a crime that occurred or an investigation of a crime that was going on when the video was recorded. That's not what this case is about.
But that's often the case with body cams. We have disagreements about what occurred. That's why we want police to wear body cams, right?
Yes, Your Honor.
So,
but in this case,
But let me just posit something, because
Sure.
I'm struggling with the second part of this. Because in Johnson, we decided there was no search because probationer with a GPS on should know better.
Right.
But I see this as different, but I'm trying to figure out the standard. If it is a search, could the standard be our Feliz standard, which is a reasonableness standard on the second search? Is that an appropriate place to turn? And if not, why not?
No, it's not. The Feliz case relies on the fact that the search in that case involved a minimal intrusion on an already diminished expectation of privacy, or the intrusion wasn't minimal, but that Mr. Feliz's expectation of privacy was diminished by his status as a probationer.
But again, weren't we looking at the whole use of GPS and sort of the standard
as a condition of probation, Your Honor.
Okay, so you say we can't turn there because it's just a probation case.
It's his expectation of privacy is substantially diminished by the fact that he's serving a sentence on a conviction.
But don't we make the larger point in Feliz that the Fourth Amendment in Article 14, we look to a reasonableness standard. That's the ultimate touchstone in this area.
That's right, Your Honor. But the way to determine whether a search of a home is reasonable is to figure out whether there's a warrant or if some exception to the warrant requirement applies.
Well, but this isn't the original search of the home. This is a secondary review because someone remembers they have this body camera of this home. And it
Your
seems
Honor,
to be
I also want to emphasize that I'm not suggesting that they can't ever look at this footage. I'm just suggesting that they need to have a neutral magistrate interposed there. The warrant requirement is.
What makes this a little unusual, Mr. Levin, is normally when police lawful, and I think Tremblay says that, there's a lot of cases that say this. In the ordinary scope of a case, when the police lawfully obtain evidence or information, they don't need a separate warrant to go to the DNA group. They don't need a warrant to go to the fingerprint group. They don't, as you well know. So
Well,
that's what makes this a bit unusual, because
Your
we
Honor,
have a lawful seizure of evidence. And then you were saying that to further look at that evidence, there's a warrant requirement.
Your Honor, respectfully, I'm not sure about that generalization. The fact that police have lawfully seized evidence does not necessarily make a subsequent search of that evidence without a warrant permissible if the subsequent search.
That's a fair point, because we've said that in the cell phone context. We've said that in other contexts. That's a fair
And the
point,
question
Mr.
is whether the subsequent search invades an expectation of privacy that society considers reasonable.
Counsel, I have a question
that's
if you've
the-
satisfied Justice Gaziano. Are you content,
Right,
Justice
right.
Gaziano?
I'm sorry, we're talking over you. I can't hear you.
I'm sorry. Has he answered your question? I have a question.
Yeah, and I just, before you answer Justice Cyphers, and you would agree with me, Mr. Levin, that this all revolves around, was there a search? Was there a
Yes.
second search?
Well,
Right.
the part of the case that we're talking about is about whether the subsequent inspection was a separate search. Yes.
Right.
I would like to go back and try to convince Justice Kapker that there is a problem with the initial recording at some point. But
yeah, I think we're all assuming that for right now, but we've got your argument on that. But I think Justice Cypher has a question, so I don't want to cut her off anymore.
Thank you. It's a short question, and that is that, would you agree that if there were no body cam, but we had a police officer with an exceptional memory, and he said, I've seen that curtain before, that's so-and-so's house, and then he went and swore that out in an affidavit and that would be okay, wouldn't it?
yes, I agree, Your Honor.
So would you also be okay with the police officer in this case saying, I think I remember that. I'm not sure. It probably was on the body cam. I'd like to look at the body cam, but he needs a warrant to get the body cam footage. Is that what you're saying?
That's right. What the officers in this case should have done is to just show that Snapchat video to the officers who responded to the domestic and see if they recognize anything in the video. And that's how you develop probable cause without conducting a subsequent search first without a warrant.
Mr. Levin, go ahead, Justice Kapker.
I'm just trying to understand. So we're in a follow-up to Justice Cypher's point. So it's okay to rely on an imperfect memory.
Yeah.
Because we know that that's really guesswork, but we can't go and check to see if that memory is correct. It seems odd, and kind of we're relying on worse evidence rather than better evidence. But am I wrong there?
Well, Your Honor, the entire thrust of this court's cases trying to apply Article 14 to developing technology is that we want to protect the degree of privacy that was present at the founding. And at the founding, if a police officer saw something and then remembered it later, that's fine. And there would be no way for him to capture that event with totally perfect recall and have later footage that can be enhanced, slowed down, paused, and potentially police would be able to see something from inspecting body cam footage that the officer who was present at the time not only didn't happen to notice, but in fact couldn't possibly have noticed just from his presence at the scene. And it's also important to note that what we're talking about is a rule that will govern future inspections of body cam footage in general. And as every police officer is outfitted with a camera, we're talking about mountains of digital footage that potentially is subject to scanning with digital software, including facial recognition technology, algorithmic searching of the video footage. We're talking about potentially enormous archives of video information that the Commonwealth says police.
That may have to await, as we said in Commonwealth versus McCarthy, a different factual predicate. But I'm going to ask you about, well, you talk about Commonwealth versus Johnson and the second search, just, there was no second search. And I imagine you'd say that's because looking at that GPS data, somebody was on probation, and perhaps even that's the argument with the stay and Garcia versus the Commonwealth. So assume for the moment that you are correct and there's a second search. When you look at cases like Commonwealth versus Almanar and other cases, picking up on Justice Kafker's last point, why wouldn't the second search be absolutely reasonable here?
Your Honor, the reason is that the police aren't allowed to obtain information about the inside of someone's home without a warrant.
But they have
The
that
United States Supreme Court has been very clear about this.
Counsel, can I ask you to explain that reason? And I think this goes back to your wish to return to Justice Kafker's question or premise, which is that first search not consented to? What's the scope of the consent, given that the body cam, as I understand it, beeps and flashes? Why is that not consented to?
Well, Your Honor, I don't know if you've had a chance to look at the video yet. I did file it for, so she doesn't ever have a chance to individually consent to this police officer's entry. There's already police in the house when he gets there. He goes right by her, he talks to her for a moment, goes by her up the stairs. You can see that you can hear the beeps on the video. The thing doesn't beep at any time when he's in proximity to her, certainly. And just more generally, it is not reasonable to expect that in order to get help from the police, you have to accede to the creation of a video recording of the inside of your house. It's fine if they want to tell you, hey, I'm recording, is that okay? That's one thing. But in this case, he didn't do anything like that.
Mr. Levin, would you have a different answer if if the police are called and they go to a public park and they record your client, and then later on they use that data? Because it would be no more different than using traffic cameras or any other ubiquitous cameras that we have all over the city and the state.
In public places, I think that body cameras are going to be controlled by a similar analysis to McCarthy, where it's a question of how much information and what type of information.
It's like a traffic stop or something's episodic. If they say, geez, I think I saw a guy that was 6'6" with bright red hair, they could say, oh, let's pull that camera up, right? That's okay?
Yeah, I mean, the crux of this case is the interior of the home, where the privacy interest is most heightened. In public places, none of the...
You answered the question from Justice Wendland about consent. What about exigent circumstances?
Your Honor, there are no exigent circumstances in this case. It's just
Police
not...
call domestic violence, and they go to quell domestic violence. It's not exigent?
There's no allegation of violence. She just says they're arguing too much, and she wants the girlfriend to leave. There's no hint or suggestion of violence at any point in this video. The other thing I would say is that even if there were exigent circumstances, those exceptions to the warrant requirement are exceedingly narrow, and police conduct in excess of what's necessary to address the triggering exception to the warrant requirement is not reasonable. And so
I'm sorry, thank you. You've answered that question, Mr. Lowe. Let me ask my colleagues if there are further. Justice Seifer has a question?
Yes, I do. And my question is, counsel, considering that your client put the interior of his home on Snapchat, which he was exposed to other people, isn't there a good argument he waived his expectation of privacy, at least in how that presentation of what was viewed in the Snapchat, which would be the same thing seen on the body cam? Why not? Why not?
No, Your Honor, he didn't have an expectation of privacy in the Snapchat video.
But it is this video of his home. And so he's revealed the video of his home to the public.
Your Honor, respectfully, that begs the question. The whole question in this case is whether or not he was in his home when he took that video.
I think Justice Kafka has a
Okay.
question.
So I'm concerned about the consent and the police cameras, because
Yes, Your Honor.
are we gonna say that everyone has the right to tell the police to turn off their camera? I'm confused about that. I mean, aren't we encouraging the use of these cameras when the police are interacting in a situation where someone may be arrested or someone may have to be removed from the house? I mean, I'm nervous
Well-
that you're imposing an unrealistic standard here.
Well, Your Honor,
And you want to encourage the use of body cameras because it allows us to evaluate what actually happened fairly. Mhm.
yes. Well, Your Honor, when you say we're encouraging, of course, there's no legislative authorization for the body cam program at all at the time that this occurred. It's just a decision by the
Is that going to be
police.
the CPCS position that body cameras are discouraged?
Your Honor, I don't have a CPCS position. I represent Mr. Yusuf.
Okay.
And
Yeah, but you
And-
get training programs, don't you?
I mean,
Your Honor, Mr. Yusuf's rights were violated in this case by the filming of the interior of his home and the subsequent inspection of that footage. And the public policy questions that you're talking about, Your Honors, certainly are weighty. And I suggest in the brief that perhaps a special needs analysis would be appropriate in a case like this. But the whole point of the special needs doctrine is that those searches are strictly divorced from the general interest in law enforcement, and information, and they're not conducted to gather evidence for law enforcement purposes. And so in order for the body cam program to be permissible on a special needs analysis, the use of that footage would have to be strictly limited. And a warrant requirement interposed between subsequent police rummaging through the footage and is necessary.
Any further questions for Mr. Levin?
One short question on counsel. In terms of the special needs searches being not for investigatory purposes, and this is, again, I know it's a hypothetical, but if the police wanted to just remove guns from the streets or guns from people who who are not licensed, but they didn't charge them, there was no charge, would there be an issue here? Would they be able to go under a special needs analysis of public safety?
Your Honor, that is not a small question. I think that's a really complicated Fourth Amendment question. I mean, you would have to go back to start with Camara and look at all those administrative search cases and try to figure out, do that balancing analysis. I mean, if it's not for criminal investigative purposes, that is a significant factor. But whether it then becomes reasonable to have the police do, sweeps of everyone's home in the city of Boston is a totally different question.
To something, but I understand. You're right. It is a bigger question.
All right. Thank you, Mr. Levin.
Thank you very much, Your Honor.
We'll hear from Ms. Martino now, please.
Good morning, Your Honors. May it please the court, Elizabeth Martino on behalf of the Commonwealth. And the Commonwealth is asking that the court affirm the motion judge's ruling that the use of the body camera footage in this case was not a search in the constitutional sense, because it was a memorialization of a civilian encounter between the police and the defendant from a place that the police had lawful authorization to be.
Are there any limits to the use of body camera footage? Mr. Levin posits that if we just say everything's fine, the police can just catalog this and then mine it for facial recognition data and do all sorts of things that would require a warrant. What do we say about limits, and what's your position on any reasonable restrictions on this data?
Right, absolutely. I think that the court has sort of indicated, and I agree, that there's a two-part inquiry, a basic framework here, which is whether the initial recording implicates any of the defendant's privacy rights, and then whether the subsequent access by the police implicates any privacy rights. And I think, when the footage is originally made for the first question, when it's recorded, the inquiry is sort of whether police were lawfully authorized to be in the defendant's home as they were here, and was it within the scope of their lawful duties, right, as it was here, as this court said in Bilicki. Then turning to the second question, which is, I think, what you're asking more specifically, is when the footage is accessed, is it accessed in a reasonable way, right? And I think that the court can look to this sort of technology cases to get a framework of when the police can access the footage. And the things that the court has looked at is sort of, is it an aggregation of data? Is it data, taken over a long duration of time? Does the technology need to be enhanced?
You're drawing parallels to McCarthy, but here what's troubling is that the police basically take this footage and they store it because they have their eye on this guy. So it's not just happenstance, and they're not just looking for it. They say, now we've got a picture of this guy's bedroom. Let's use it for later investigative purposes. Correct?
No, I would respectfully disagree. I think that the footage. So it was a service call, right?
Right.
The sister called.
No, assume the first one was okay, but then they burn a copy and they keep it for later investigative use. Correct?
Well, I think that the record indicates that it was 10 days. So the gang unit was looking into the defendant because of his Snapchat videos, right? And he had multiple Snapchat videos. And about 10 days after this domestic call to the defendant's home, right? Nobody had linked the calls yet. They were looking at the Snapchat videos, and then the officer said, let's see if anybody's been to the defendant's house recently. So they did a search of his residence, and they found, 10 days earlier, police responded to his home for a service call. And then they said, and somebody was wearing a body camera. Let's look at the footage.
So I guess stop there. Why is that not an invasion of a reasonable expectation of privacy? You're positing that the only question that we need to answer is whether they access this in a reasonable way.
Mhm.
And I guess I'm still stuck at whether or not that second reviewing of the data of that address
Mhm.
is a search.
Right, so the Commonwealth's position, right, is the recording itself is not a search, right? Because it's just a memorialization of what happened within Balicki. So going back to look at the footage is not a search, because it's just a record of what happened when the police were inside by consent, right?
So assume I don't agree with you that the recording of the body cam recording is not a search. Let's just say it is a search, but it was consented to, making it not a Fourth Amendment violation.
Okay,
Posit that.
okay.
Now answer my question. Is the second accessing of the data a search? Does it invade a reasonable expectation of privacy, subjective and objectively?
No.
Why not?
Okay, so I think there are certainly situations where it could, right? Where it could amount to an implication of the defendant's rights, but not here. And that's because if the officers slowed down the video, zoomed in, if they were to look for details that were otherwise unknowable, right? That's what the technology cases focus on, by combing through data, whether it's cell phone records, license plate readers, poll cameras, all of these technology cases talk about revealing information that was otherwise unknowable.
But so can I stop you, counsel? Because you're going to whether or not the access was done in a reasonable way by zooming in, slowing down, whatever. I'm still stuck at whether or not the accessing itself
Mhm.
is a search,
Right, and so
invading the defendant's reasonable expectation of privacy.
right, so I think what my answer is the only way we determine if it's a search or not is if it's unreasonable, right? So does it invade on the defendant's reasonable expectation of privacy? And the answer is only yes if it was an unreasonable accessing, revealing of information otherwise unknowable, which here it's not.
Is that too narrow? I mean, Justice Wendland's point, when I'm comparing it to Johnson. If I'm a probationer wearing a GPS device, I know that they're going to look to see what that data shows. But this guy, once they leave his house, he doesn't think they're going to save this data. And isn't it reasonable? He says, okay, this was a domestic incident that ended peacefully. There's no claim of police brutality or anything like that. So he thinks this is over and done with. So doesn't he have whether it's reasonable for them to access this is, to me, the next question. But in response to Justice Wendland's question, doesn't he have a reasonable expectation of privacy in the storage of that body camera information?
No.
He doesn't think they're gonna, I wouldn't think anyone would be saving that kind of stuff on me if they showed up at my house. I mean, why would I think they'd save that?
Right. The answer, quite directly is no, there is no reasonable expectation of privacy, that the
Well,
police
well,
are not.
tell me
gonna record it.
why, as opposed to
Right.
there isn't.
Right. And I think that's because, when a individual calls the police to come to their home to aid for a service call for domestic violence, whatever, they know that the police are going to come in and that they're going to see what they're going to see in their home, and that the police are going to document that encounter in some way, right? Whether
They're
it's
gonna-
writing.
They're gonna
Police report.
document what my shades look like in my house. They're gonna document this, how my house is laid out, even though the incident is over and done with.
Absolutely. They're going to have a memory of what occurred. And like Justice Seifert mentioned, there would be no question if, the gang unit here had the Snapchat videos and they went and they looked, has anybody responded to the defendant's home recently? Oh, look, 10 days ago, they responded to a domestic call. Let's show these officers the Snapchat video.
Didn't Justice Alito tell us not to do that? Didn't Justice Alito tell us that if you could, saying that the police could just follow someone or use their great memory, that's not how we look at these enhancements. Because, if that were the case, we would just say all GPSs are fine because the cops could put armies of cops out on the street and follow people. So that can't be the answer, right? When you cite to us McCarthy, the poll camera cases, as Mr. Levin points out with citing Kylo, what you're not addressing is the home aspect of this, as opposed to the outside aspect. And that's a question I asked Mr. Levin about if this was a car stop, different story. Address the home protections inherent in the Fourth Amendment in Article 14 on the reasonable expectation of privacy.
Right, absolutely. So those cases are where, the police are in a lawful place, perhaps outside of the home. And then they're trying to gather information from inside the home using technological enhancements. That's not the situation here. The police were lawfully inside the defendant's home by consent. Right? It's a totally different situation than Kaela, which is a thermal imaging case where the police are outside the home and then they're using technological enhancements to try to garner information from inside the home. That's why the Supreme Court said all details are intimate details. You're crossing a threshold here.
But I think you're reading it a little bit narrowly, because the issue is in all our search and seizure case law involves the added protections of the home as opposed to being outside the home.
Right.
It's the intimate details of one's home which gathers the most protection, as opposed to a vehicle or your whereabouts on a public street.
Right, but those are when the police are not lawfully inside the home. That's the major difference here.
Isn't there a difference in kind? I invite somebody over to my living room. I don't expect them to be videotaping the living room for later review. I mean, I guess I'm still stuck at the reasonableness of the storage and the accessing of this at the end.
Well, I think it all has to be sort of taken in context, right? And I think that the videotaping here was a pure memorialization of the officers.
But
what
then
he
when they
did.
access it, it's not memorialization anymore. They're using it for investigative purposes to compare it to the Snapchat that's been recorded.
Right, but what they're going back to look at is just it's the same thing. So in Balicki, right, this court said if the police are somewhere where they're lawfully allowed to be, like executing a search warrant, or they're inside the home because of an exception to the search warrant, they're allowed to photograph or videotape. It's a limited intrusion that doesn't implicate constitutional rights, right? They are allowed to videotape just what's within the scope of their duties.
But what they can't do is turn over the toaster to look at serial numbers to see if it's stolen. They can make general observations and the like, but they can't do, and that's what Balicki says in a lot of cases, say is the police exceed the scope of their authority, as Justice Swinland is asking you, but they can't do added things like look at serial numbers or look into the closets or the drawers, right?
Of course, which
So
the
here
police-
digitally, they're looking at this for granular information as to what the curtains look like.
Well, I would respectfully disagree. So Balicki, right, this court said, as long as you're lawfully inside, you can preserve, what the officers did within the lawful scope of their
Right, but
duties,
this is
right?
an extension of
Yeah.
Balicki, because now you're saying, use what you lawfully obtained. Balicki says it's fine, and now use it for a second investigation.
And counsel, I would push back on that because in Balicki, didn't we say you could memorialize what you were there for?
Mhm.
But then when you get more than what you were there for, you can't use that extra to then get another search to do more. And isn't that exactly what they did here? Isn't that what we said they couldn't do in Balicki?
No, because the police didn't see anything more than what they did exactly in their lawful duties. And in fact, that's why we have the motions to suppress, right? I think that the motion to suppress is the protective measure here for a defendant's rights, right? So we have the footage was
I
taken.
I thought we were.
Yes, and we're reviewing what the motion judge, right, made the decision. And then we're also, here to make sure that the motion judge was correct. And it's because, right, the footage was taken when the police were lawfully inside. It was totally within the scope of what the officer was supposed to be doing. If you look at the video, right, it shows just that he went upstairs, removed the defendant, left. He did not go outside the scope of his duties at all. He did not rummage through drawers. He did not inventory the house. He did not do anything outside of the scope of his duties, right? And then the police later accessed the video they didn't enhance it. They didn't slow it down. They didn't, aggregate any data. It was from 10 days before. It was a timely nexus. And they found just a detail that was in plain view. It was not otherwise unknowable, right? And then the defendant
Counsel.
filed the motion.
I'm sorry, counsel, I'm listening to this and the
Yeah.
question comes to my mind. Why is it so difficult for the police at that point to just write an affidavit and say, I think I do remember something. I'd like to confirm it. It's, that could reach probable cause, especially with the Snapchat information, and get a warrant to search the state.
Well, the simple answer is that it's not required because there's not a search, to access the video. But if it were,
But if there were a
required,
search, if it were a search, if we said this is a search,
absolutely, then the
then a
Commonwealth
warrant would,
that
okay.
they would have had probable cause for
One more
that.
question and I'll turn it back over. Do you have any cases or examples where police have gone into a home, taken photographs for a valid reason, gone back to the police station, tucked them away somewhere because they don't need them, and then someday later somebody's going through and says, this is the photo I need to show that so-and-so's connected to this crime? Do we have anything like that?
I don't think I have that case, Your Honor, because police do that all the time, right? Police take pictures all the time
So
of
how
a
is
crime
that different
scene.
from this?
It's not, and that's the point, right? Police take
Uh-huh.
pictures all the time. They if there had been injuries in this case, or if there had been a melee and, furniture had been knocked down, the police may have had to record that by taking pictures. And there's no question they would have been able to go back and look at those pictures, right? That's why we don't have a case on point saying you are allowed to do that, because police routinely go back and look at their pictures of crime scenes taken inside the home, of pictures of, victims' injuries taken inside the home, of police reports written about, things that happen inside the home. They routinely go back and look at that stuff, and we never question whether they're allowed to do that. Of course they are. It's a memorialization of the encounter that occurred inside the home with the legal authorization to be inside the home.
Can I ask you a question I probably should know the answer to?
Yeah.
But you'll help me out. Is there any BPD guidelines that govern retention and search of body camera footage?
There is, yeah, I believe, that there is a policy. I think I
Is that in the
included it.
record?
It's not in the record, no. So it's not in the record, and I don't think that that's necessarily a problem for the Commonwealth's case. I know that there was a
Well, if you
testimony.
if you exceeded those guidelines, you'd probably have a problem, because that would indicate a reasonable expectation of privacy based on those guidelines. So I guess the question is, why aren't they in the record?
Well, I would disagree with that, Your Honor. I don't think that the policy sort of indicates the answer to the constitutional question.
No,
about
but
whether
it would
there's an
give the
expectation
citizens of this of Boston some expectation of privacy, knowing that the police shouldn't exceed their own guidelines, right?
Well, no, I would disagree. I would disagree with that, Your Honor. I think the basic question here was, were the police lawfully inside the defendant's home, and they were by consent, it's not even contested, right? And then it just becomes a question of, was the later access of
Right,
the
and
footage.
if the use of if the mining of this data exceeded the BPD guidelines, it'd probably be an issue.
Well,
correct?
and I would disagree again that there was any type of mining of any data.
I know,
right?
I know characteristics are important.
Yeah.
But,
And I think
Can I ask-
be
can I ask
as
a-
it may, that's not part of the record, right?
it was not introduced at the,
And isn't the record, I'm remembering Mr. Levin's brief, and I haven't checked the record, but I think there's argument in the brief that the police testimony was we preserve this data forever. Is that correct? And is that what we have to work from here, even though it's inaccurate? It's
I think so.
inconsistent.
I think so, sort of, that is the record before the court, but what I think is
So
important.
does that raise some troubling issues for us? Because if the record we're dealing with is they keep this data forever, doesn't that raise sort of some McCarthy or issues about an agglomeration of data that can be misused if it's not controlled?
No, it doesn't. And that's because the question is what actually happened in this case. And what actually happened in this case is that the officers accessed one body camera from 10 days earlier. It doesn't matter that it's may be kept forever. Here, it was a timely nexus, right? It was 10 days earlier.
Well, but
And
it relates to the Balicki issue of whether everything here is reason, are we using it for this case, or are we data mining in ways that are troublesome? Because Balicki says, okay, you can take pictures as part of a search, right? Because it memorializes the search for that particular case, right? Balicki is a little bit different, right? The issue is whether it was all part of that case. This is a totally separate incident being used here, isn't it? Doesn't that raise different sets of questions if the data is going to be used forever?
no, because it's about when the police access it. And here they accessed it 10 days later. And that's the issue before this court, whether what the police did when they accessed the video was reasonable,
So
right?
if they
it-
accessed it a year later, it would be unreasonable?
Possibly, I don't know. I mean, I guess. that would
What is
be-
the limit to this 10-day period?
Well, I think it would be, litigated at the motion to suppress, right? And that's the protective measure that we have for defendants here about whether their privacy rights were implicated.
So
if a
10 days
defend-
later, no privacy, but maybe 20 days later, there would be privacy? We don't know. That's the legal
Well, I
regime you
think
want us
it's
to set up?
probably, it's the standards. I'm not saying necessarily the standards of a search warrant exactly, but here, right, the officers wanted the information to put it in a search warrant. So they needed to have a timely nexus, right? So the curtains needed to be at a time where they could still say the guns are
How was
probably in the
this
house.
data accessed? Wasn't it by address?
Yes.
So when you say it's not data mining, it actually is, right? If there has been more than one service call at this address, it would have pulled up all of the body cam recordings from this address, right?
I don't know if there was more than one. I mean, it would have probably pulled up all the times that the officers were
Right, so I'm a
there.
police officer and I'm investigating a defendant for whatever crime, and I know that he lives at X address. All I have to do now, because this data, according to the record, is kept forever, is look in the database and see if there's ever been video footage of his apartment.
Right, but again, as this court has said in all these kinds of technology cases, yes, there's a world of data out there, but it's about how the police use it, right? And here, it's a targeted, limited analysis. It's one time, right? One entry by the police by consent. It all
I
has to
understand
be-
you want to limit the discussion to this case. I'm trying to get into a more, I want to figure out what legal regime we should be setting up, because it sounds like, based on the record here, the police are collecting data on the interior of people's homes, making it searchable by address, and then searching it for defendants' addresses.
I would disagree with that. I don't think, what happened here is that the gang unit looked to see if anybody had responded to the defendant's home because they were investigating the defendant.
You think
When
this is
they
a
found
one-off?
that police had responded to the defendant's home, they saw that one of the officers was assigned to wear a body camera. It wasn't like that they were looking for body camera evidence.
I guess that's
Is the
that's the issue.
distinction.
You're saying that this is episodic.
Mhm.
And if you zoom out to Justice Wendland's question, Let's say they then get the address. They go and they input the address to see how many service calls have resulted in police going to that address. And there are 50 entries. And then they go further to see whether or not anyone that responded had a body-worn camera. And then they go to the footage of October 1st, 2017, that's kept forever to see if they see anything. I guess that's the regime question is, this is a question of applicability to the entire Commonwealth, not just this case.
Right.
So what do you say about that?
Well, I would say that would be, perhaps a situation where the defendant's privacy rights could be implicated, right? If it were that long ago and it were, the police had mined through lots of data in order to get there and had, used these sort of technological and perhaps, of course, I'm not being, unreasonable. There may be a situation where the access does implicate the defendant's rights. And I think you can look, I know Justice Kafka was looking for, sort of a way to figure out where it does implicate their rights. And I think you look at those technology cases. Are we aggregating data? Are we data mining? Is it timely? Do you have to use technological enhancements? You can look at the McCarthy, the Mora line of cases, right?
Yeah, Ms.
That's
Martino,
not
I think
here.
what you're saying is that these are really important issues to be litigated. But like Commonwealth versus McCarthy, we've got 4 cameras on a bridge. Let's decide that case.
Right.
And then we've got all these huge issues
Right.
that we should decide when we have those facts. I
Right,
think that's what
exactly.
you're saying.
And of course, each individual defendant may bring a motion to suppress to say, I believe under these circumstances, and
Then
the
we
access
have those facts.
exactly may have been violated. And then you have the recording. So the motion judge at the motion to suppress can look at the recording, can look to see if when it was recorded, did it go outside of the scope? Were the defendant's rights implicated? They'll have the video so they can look at the time the recording was made, were the defendant's rights implicated, and then they can look at the access, right? The motion judge can look at the access.
Or we can look at the subjective and objective expectations of privacy with facts.
Exactly. Exactly. So that can be, but on these facts, in this case, there was no, expectation of privacy, no privacy rights implicated when the officers entered the defendant's home because the sister consented for them to be in there. The officer stayed within the scope of his duties when he went and removed the defendant and his girlfriend from the house. He did not film anything outside of the scope of his duties. And when the officers later went to access the footage, they did so in a reasonable manner. There was no aggregation of data. It wasn't over a long duration of time. It was a targeted analysis. It was all the reasonable things.
That's a second part Feliz analysis though, it gets me back to the question I asked your brother. So if we find the second one is a search, can a sort of a reasonableness standard be imposed there, or does it have to be probable cause or like Arcola, minimal, absolutely minimal type of intrusion?
So it doesn't have to be probable cause. And I know that we keep going back to like, this was inside the home, but it was inside the home because the police officers were consented to come inside the home, right? So again, like a probationer's diminished expectation of privacy because he knows that he's got the GPS on. Here, the defendant knows that the police were inside his home, right? His sister said, come on in. And so when somebody calls the police, they expect that the police are going to come in, that they're going to look around, that they're going to see what they're going to see, and that they're going to document it, right? So there is this diminished expectation of privacy, or as the Commonwealth would say, no expectation of privacy at all.
I don't see them. I have trouble with the documenting point. They document the incident. They don't document the curtains or whether the guy has a nice house or not. That's where I wonder whether we're going beyond Balicki when we save the inside of the house when it has nothing to do with the police incident that we're dealing with here.
Well, I would say that, within what the police did here was within Balicki. And so then the question is, what the accessing of it. And I think, again, imposing a reasonableness standard to determine if there is some type of privacy right implicated is the appropriate one. And I think that the factors that the court can look at are sort of, did they have to zoom in? How much data did they go through? Sort of the things in McCarthy, Johnson, Mora. Was it, historical data over a lot of time? Was it multiple, data points, or was it a targeted analysis, such as it was
Let me
here?
ask if there are any more questions. Thank you, Ms. Martino.
Thank you.